J. Suresh because he is with us from the first day onwards. So, Suresh, sir, let me extend you a warm welcome to this final day.
Thank you.
Yeah. So, dear participants, let me give you some instructions before we get started. So, our today's session is on copyrights and designs. So, if you have any questions during the presentation, please type them into the chat box. We'll bring them up during the presentation if necessary, or we'll also have time for the questions at the end. Okay, so now without further ado, we will turn the time over to Advocate J. Suresh. How about you, sir?
You're good. Ready? Ready to go.
Yeah.
Is my screen visible?
Yes, sir. Yes, sir.
Okay, good. Good evening and warm welcome back to all the participants. So, this is the final and third day of our interactions. And in the last two sessions, we have had an interesting exchange of thoughts on tangible and intangible properties, knowledge goods, and we have spent considerable amount of time on goods with utility, that is patents, how inventions can be protected, how discoveries cannot be treated as inventions, so on and so forth. Now today we are moving on to a different species of intellectual property rights, that is copyrights and industrial designs. The reason for considering discussion or this copyrights in detail, for the reason that being from you people being from the academic domain or with academics background, what I thought it is relevant to understand the implication of this particular species of intellectual property right, for the simple reason that in academic circles, it is a common practice to use the literature, books written by others, of course, in the course of education. But nevertheless, it is always better to know the implication of law because ignorance of law is no excuse, as we all know. To draw a line between what is permitted and what is not. And we will move on to the next species of intellectual property rights, that is industrial designs. So let us start. So today, as I mentioned, we are going to start with copyright, which permits only the author having a right to copy. And then designs, where the protection by law is offered for non-functional shapes and configurations. So broadly, this is going to be our session. In order to understand in a right perspective the present state of copyright laws, it is preferred to go back into history to see how this particular field of law has evolved over a period of many centuries. See, if you look at early origin of this copyright law, we could find instances as back as 6th century BC, where ancient Greek, Roman, Jewish cultures had this issue of copyright. There is a story which happened as back as 6th century. The story goes like this. Uh, at the time, there was a country called Venice, and in that country was ruled by a king called Carbale. And during that time, there was a book written on Psalms, Book of Psalms, that was written by Saint Finian, who was one of the subjects of the king of Venice. And during that time, his assistant called Saint Columba wanted to have a copy of that book of Psalms written by Saint Finian, for which Saint Finian did not agree to. So, what Saint Columba did in the middle of the night, which was considered as a miracle, there was a light, miracle light. So, he was able to make a quick copy of the book of Psalms. And then, since Saint Finian was objecting to that, he went and complained to the king, saying that Saint Columba did like this. Then king issued a warning to Saint Columba, saying that no, this work this copyright on this book originally belonged to Saint Finian, and Saint Columba was unhappy and angry, so he waged a rebellion against the king. The king, at the time of passing this order against Saint Columba, he said a statement which is still now is very popular among the copyright folks. What he said was, to every cow belongs its calf, so therefore to every book belongs its copy. So let me repeat this again. To every cow belongs its calf, therefore to every book belongs its copy. So that was a statement made by the king while ordering for that. And this particular statement even still popular during our time. So after this, Saint Columba waged a rebellion, and it was narrated in the story that there were about 5,000 people died for this issue. So we feel that people of modern age are more litigious than our ancestors. But here we could see way back in 16th century, people were more litigious than what we are today. So that was one of the early instances where there was an issue about copying from one source to another source. As time progressed, and then with the progression in technologies, in way back in 11th century, in China, they invented something called movable type printing press that you can see here, where these letters are movable and they were able to print those letters on a medium. It was called as movable type printing press way back in 10th or 11th century in China. And as and when this particular technology evolved, copying became very easy. Say, for instance, in 16th century in Europe, when the development of printing technology was it was developing very rapidly, so they were able to replicate or reproduce these books very easily. Prior to that, it used to happen that, say, for example, during the time of Romans, copying from one source to another used to be done by manually. And they were having what you call as literary slaves. The Roman emperors were using literary slaves for making copies of original version. So as the technology developed, then we got this printing machinery, so which enabled easy copying of the books and the literature. So there was a need felt to have a law in place to govern this reproduction of books. So way back in 1710 in England, a statute of Anne was promulgated or enacted. This is one of the first, what you can call it as uh, statute on copyright, based on which all most of the modern copyright laws are based. So now, what is it in this statute of Anne is that prior to this, they were there were rights in the copyright was considered to be infinite. That is, if somebody has a right, he could have it for an infinite period of time. Since the IPR laws are based on quid pro quo, that is something in return. If somebody is enjoying a monopoly, what is it it gains for others? So based on that, so this statute of Anne came about with saying that these rights are not infinite but finite, and for a period of limited period of 14 years. Then in case of book already published, they said the rights could extend up to 21 years. And then primarily this particular enactment was to encourage learned men to compose and write useful books. Okay. Now, since the laws of each country, as we understood in previous sessions, that IPR laws are territorial in nature, as a result of which there is a variance between or among the various IP laws. So in order to bring in a minimum standard of uniformity, Berne Convention was enacted in the year 1886. It was formed rather. Under this convention, to which India is also a member country now, for the first time, literally scientific and artistic works were considered to be copyrightable subject matter. In addition to that, Berne Convention was amended in the year 1928 to include special rights called moral rights, which we are going to look into more detail. In other words, these moral rights are independent of copyright. That's one distinction at this stage we need to remember. And Berne Convention also brought in something called national treatment. That is, if I am an Indian citizen and if I have certain rights for the works that I create, say for example, I create a literary work in India, being an Indian national, Indian law provides me certain minimum level of protection. So under Berne Convention, it says the amount of protection that you are offering to your own citizens should also be given to the citizens of other countries. That's called a notion of national treatment. And also, other thing that was brought under this convention was minimum standards. That is, the term of a copyright was fixed at 50 years uh, after the passing away of the author. That is, author's lifetime plus 50 years. So therefore, Indian copyright law cannot come out with a, say, an enactment where Indian government says, no, I'm not happy with 50 years. I would offer only 45 years. So which is violating the convention. So India, we could not do that way. So the convention provides for a minimum level of standards. So now the term of copyright was considered to be life of the author plus 50 years. And other important thing that was brought by this Berne Convention was in order to get a statutory protection for the copyright work. Say, for example, you write a book, and in order to get a copyright registration, was there any necessity to apply and secure registration from the respective government? So Berne Convention said, no, the moment a work is created, copyright subsists from that day onwards or from that moment onwards, rather. And this convention also highlighted the plight of authors because prior to these conventions, authors were deprived of the what do you call it as monetary benefits of their works because publishers were dominating them. So under Berne Convention, there was a protection was brought for authors who create original works, whereas the publishers are those who publish and then monetize that particular work. So these are the some of the main features of Berne Convention. Why I'm trying to highlight these features because these features continue to exist in the copyright laws of various countries. Now, as we know, every law has an exception. So the exception here for the copyright law is that uh, reproduction of these works can be done without obtaining owner's prior permission. So that is what an important limitation and exemption where one can use the subject matter of the original copyright without obtaining permission from the owner or the author of the copyright. In India, we call it as fair use exception. Sorry. In US, it is called fair dealing. Now, if you look at the Indian law, copyright law, we have a Copyright Act of 1914, and then which was amended post independence, that is 1957, which is currently in force, amended as late as 2012. In the year 1999, Government of India passed an order under Indian Copyright Act saying that publication of work in any other member country treated as publication in India. Why is it so? Normally, when I publish a work in India, and then the publication is deemed to be or is considered to be within the territorial geography of India. But this publication could not be extended to another country, say in US, where I say my work, which is an original work, was published in India as well as in other country to make it enforceable. So under this copyright law, in this international copyright order, publication of a work in any other member country of Berne Convention could be treated as publication in India, right? Now, what is this copyright? It is a legal right, we all know. Right to copy, that is, it is a right bestowed upon the author, where author alone is permitted to reproduce the work. And it is for limited time. In India, we have a life of the author plus 60 years because minimum as provided by Berne Convention is 50. So Indian government is providing more than what it was provided under Berne Convention. Other important thing that we need to remember here is when we talked about patents, we said ideas, that is functional ideas, are patentable. Whereas when we talk about copyright, we say only expression of ideas are patentable. Whereas ideas per se cannot be, expression of ideas can only be protected as a copyright, and ideas per se, you cannot copyright them. Let me give a simple example of, say, We have a very well-known epic Ramayana, which was written by Valmiki, and then we have a dramatized version of Ramanand Saga's Ramayana. So that's an idea everybody knows. Characters everybody know, most of us know. Uh, so therefore, the idea is well known. However, we have various expressions of that idea, and each expression can qualify for a copyright. If I write a story based on Ramayana, then I can become an author, and I can claim copyright over the expression of that particular story. So, as I said, these rights are not absolute, and they do have exceptions. When you talk about copyright, it is not a single right, it is a bundle of rights. So, according to the Indian law, if you see our Indian Copyright Act, these rights are literary, dramatic, musical, and artistic works. So, these are all different types of rights, different types of original works that we can call. And in addition to that, we have cinematograph films and sound recordings, so on and so forth. So whenever we talk about copyright, it's not a single right, but it is a bundle of rights. Okay. Now, however, we can divide this copyright broadly, this bundle of rights rather, into two categories. One category is the statutory rights, that is right to copy. That's called the statutory rights. Statutory right, literally, if I am claiming a statutory right for literary right, I am the author of the book. Therefore, law only permits me to reproduce or make a copy of that book, but no other person is allowed unless I permit to do so. Similarly, we have, on the other hand, a very important special rights called moral rights. That is, even in the absence of a copyright, a person can still exercise moral rights in the copyright. So we are going to see in this session what these moral rights are, how these moral rights are enforced. Now let's go back to the exclusive rights, that statutory rights. As I said, we have literally artistic, dramatic, or musical work. Now, what are these exclusive rights that we talk about? When we talked about patents, we said the exclusive right to prevent others, the using my invention. In a similar way, under copyright law, we do have this negative right again, that is, it prevents others from using my work. How this prevention is happening here under copyright law? That is, in case it is a literary work, the right is to reproduce the work in any material form. I only have this right, but others cannot do that. I prevent others from doing this. That is what? Reproduction of the work, literary, artistic, or dramatic, or musical work. Issue copies of the work to the public. I see that right is only vested in me. To perform the work in public, say if I have written a book and I want to perform that particular, dramatize that in public, so I only have a right. I cannot, this right is not available to others. Making a film, yes, or a sound recording, to make any translation of the work. Say if I write this a book in English, somebody wants to translate this in French, they should take permission from me, because that right is automatically vested in me by virtue of the creation. That is exclusive right. Adaptation of the work. Say if I have a book and I want to make a drama, so if somebody wants to do that, they need a permission from me. So these are some of the exclusive rights that we see for copyright holders. Now, if you talk about this, continue to talk about this literary work, early here we mentioned about what are the rights, and now we are going to take up each and every type of this exclusive right. Firstly, let us take this literary work. When you talk about literary work, that means it could be prose or poetry, anything falling under literature. So the literary work also covers the printed versions and the writings. And interestingly, in India, computer program is considered as a literary work. In other words, if you have a computer program written by you, you can protect that particular computer program under copyright law. An exception to this literary work is that, uh, generally speaking, uh, under copyright law, there is no requirement of artistic quality. So, for example, if somebody has written a story, uh, which is a common story, and then somebody else modifies it, so there may not be any qualitative addition to an already known idea. So therefore, the exception is that, uh, generally literary work does not require a higher standard of what do you call it as artistic content. But nevertheless, if it is going to be a mere collection of words without any literary skill, generally those works are not considered as original works. Now, next is, let's move on to dramatic work. Say, if I write a poem, writing a poem is literary work. And when I do the recitation of this poem, and it becomes a dramatic work, it is adapted to a dramatic work. Therefore, if I write a poem which is a literary work, my protection extends to an adaptation which is a dramatized version of my literary work. So if somebody does a choreographic work, it is a dramatic work. Scenic arrangement, uh, acting form of which is fixed in writing. However, there is an exception to this dramatic work, that is cinematographic films. Cinematographic films are not considered as dramatic work because they per se are considered as a separate form of uh, work. That's the reason why it doesn't fall under dramatic work. Now, if you look at the musical works, generally graphical notation of such work without including any words, and those are considered as musical works. Okay. Now, as far as artistic works are concerned, paintings, sculptures, drawings, they're all considered as artistic works, including diagram, map, chart, or plan. So all these works fall under the category of artistic works. Even architecture is also an artistic work. Likewise, we have engraving, photographs, color schemes, layout, all these things, they fall under the category of artistic works. Now, as I was mentioning, cinematographic films are considered as a separate category of copyright. So here, how these cinematographic films are defined under copyright law, it is like any visual recording on any medium along with a sound. So therefore, if somebody records a visual recording through a process from which a moving image is produced by any means, including a sound recording, that is defined as cinematograph films. So person creating this particular medium or this particular work will hold the copyright. That's called copyright over cinematograph films. Now, next is sound recordings. If somebody records a sound on a medium, such recordings are called sound recordings, and the person who is recording these sounds on a medium would hold copyright on the recordings. Now, as we will continue to talk about this exclusive rights, so when you take up this computer program, the exclusive rights on this particular type of literary work, which we call it as reproduction rights, that is the right to sell, give on hire, offer for sale, or hire any copy of the computer program. So that means if you have written a computer program, these are the exclusive rights that law provides for you. That is, it prevents other from making or selling, hiring, or making any copy at their end. Okay. Now, as far as cinematographic film is concerned, what are those rights that are given to the creator of this film? That is, uh, others cannot make a copy of the film, including a photograph of an image. Say, if there is a film is made, you take a picture of that a part of that film, which is not allowed, and to sell or give or any copy of the film and to communicate the film to public. So, uh, if you do so, it will be a violation of a copyright in that film. Now, so far we have seen exclusive right, that is exclusive copyright, uh, uh, which is provided by the copyright law. Now, let us look at, in addition to this exclusive rights or statutory rights, law also provides for something called special rights. What are these special rights? Let us try and look at them. These special rights are independent rights. That means, say, if I make a portrait of a particular person, and after making this portrait is an artistic work, what I do for a consideration, I sell it to, say, a person B. So I no longer own that particular portrait. I've sold it to person B. So, and the person B pays me money. You take this money and then you forget it. So I take that money. Then thereafter, what the person does, and he mutilates that portrait. Like, say, for example, I've created a lady portrait, and then after buying from me, he obliterates that portrait, and then what he does, he puts a mustache to that portrait. So that means the rights that are there in the copyright, that is what you call rights, that is the moral right, we say, because of my moral right means my reputation, everything, goodwill, everything. So that is being mutilated or obliterated. So here the law comes into picture. Since I have sold it already, I have no right to claim my copyright back. But the work that was sold was getting mutilated. So what is the remedy that is available to me? So in this context, copyright provides for special rights. That is, even if I sell my rights in the copyright, still I can claim back my rights as a moral right. So that is what is the importance of special rights. Now, I'm going to share with you some of the pictures, and I want you to think over these pictures. Probably some of you who have traveled to Delhi somewhere in 70s, 80s, probably you may find this in Vignan. You would have found this rather in a place called Vignan Bhavan. This is nothing but what you say is a mural, where you see it depicts culture of Indians like artisans, farmers, so on and so forth. And when former Prime Minister Jawaharlal Nehru, when visited this Vignan Bhavan in the 1960 to inspect this mural, you can see this mural on the walls, that is arch, main entrance of Vignan Bhavan. It is about 40 feet in height and about 140 feet in length. Huge mural. And this mural took about 3 years, more than that, maybe 5 years, to make this work appear on the back, on the medium, or here it is going to be the arch of the Vignan Bhavan. Now, why is it that we are looking at these pictures? Right now, let's go ahead and see. This particular picture that we mural, sorry, the mural that we see was done by a very famous sculptor called Amarnath Sehgal. And government of India hired this particular sculptor in the year 1956 to have this mural for Vignan Bhavan. And he undertook that. And after 4 years, in the year 1960 or 61, this mural was ready. And that during the inauguration, this mural, uh, Jawahar Pandit Jawahar Nehru was present. So, and this particular mural became very popular because Vignan Bhavan used to be the center where foreign dignitaries used to come. And whenever they visited this place, they were amazed at the work done by this Amarnath Sehgal. So it became very, very popular. Now, so when this particular sculpture was done by Amarnath Sehgal, what happened was there was a fire accident in Vignan Bhavan. And during that time, they removed this mural and kept in a warehouse. Right? And when sculptor knew about this, he brought a legal action against the government of India. Right? And the case was filed in the Delhi lower court, and then ultimately it went to Delhi High Court. So during the course of this legal proceedings, Amarnath Sehgal argued, first thing, you have mutilated my work by throwing it in a warehouse. So therefore, you return my work to me. Right? And all the rights in the mural, you transfer that to me because you have not been using it properly and you have shown disrespect to me. So therefore, you return those rights. Then you give me damages. And secondly, he said, contractual terms, that is, when they formed an agreement between government of India and Amarnath Sehgal, they said there was a clause in that agreement which said moral rights are independent of author's rights. So therefore, he said, my copyright, my moral right in this work continues to exist even after I have sold this work to government of India. Right? Now, the defendant in this case, government of India, in their reply, they said, see, we have executed an assignment of copyright with you. Assignment is nothing but a sale. So you have sold us the copyright in the work to us, and therefore you have to forget it. You don't have any other right to talk about in this. And then they said all rights vest with the government of India. After long legal wrangling for about 15 years, and then imagine it started off and then went on for about 15 years. Then the court held in this case saying that the work was too precious to be reduced to scrap. And then court granted relief to the sculptor, that is Amarnath Sehgal, and awarded damages of 5 lakh rupees. And they said rights are vested in the plaintiff, that is Amarnath Sehgal, and he has absolute right to create the mural at any place and to sell the same. However, Amarnath Sehgal did not take the damages because he was a very well-known sculptor. His fight was for his goodwill and reputation, probably not for money. He refused to take that money, but nevertheless, he took his copyright back. Okay, so that's about special rights. What is this thing? The thing which we can carry from this case is that the moral rights of a person, of an author rather, continues to exist even after the termination of the copyright. In this case, Amarnath Sehgal sold his copyright to Government of India, but nevertheless, he was able to retrieve his copyright as well as his reputation because the work that was created by him apparently was reduced to scrap. That means his reputation and goodwill was spoiled by doing this, and his work was brought to disrepute. Okay. Now, let's look at the authorship now, because the authorship on a copyright varies from one category to another. See, if you create a literary or dramatic work, the question here is who is going to be the author? Because if literary means if you're writing a book, are you the author? Or if you're dramatizing a work, are you the author? So here we need to identify very clearly who is going to be the author. In case of a literary work, the author of the work. That is in accordance with the copyright law. If it is a literary work, the author is going to be the author of the work is going to be the will have the authorship. What about the musical work? Please see the difference here. In case of a previous literary work, we said the person who wrote that book. Here, the person who composed the musical work. The composer will be the author here. Whereas in case of an artistic work other than a photograph, artist is an author, is the author. Okay. Now, if it is a photograph, who is going to be the author? That is, the person taking the photograph is considered to be the author. If it is going to be a film, the producer is going to be considered as an author. And if it is going to be a literary, dramatic, musical work, which is computer generated, here it is the person who causes the work to be created. That's very important. If it's going to be computer generated, the person who causes the work to be created would be treated as the author. Now let's understand the difference between authorship and ownership. Author shall be the first owner. That's by default under law. If a person who creates is considered as a first owner, right? And there are situations where first owner could be other than the author. What are those situations? Say, for example, a newspaper proprietor will be the first owner if it is done, if it is created, work is created by, for example, say an editor, because editor has created this work in the course of employment with the proprietor. So therefore, the first owner in this case would be the proprietor, not the author. In case of a photograph or film, if author at the instance of a person for a valuable consideration produces or creates, let us use the word, captures a photograph or creates a film, such person is the first owner. So for instance, for all weddings, we hire a photographer, right? And photographer takes pictures or photographs. And now the issue here is who is the first owner of this or those photographs captured at the wedding? Is it going to be the photographer or the person who hired the photographer to capture those photographs? So according to law, since the consideration is paid, valuable consideration is paid to the photographer, the first owner of the photograph would be with the person who hired the photographer. Okay. Now, in case of an employer, if an employee comes out with a work which is original in nature, employer will be the first owner because employee created this work in the course of employment and using the resources of the employer. So in such a scenario, employer would become the first owner. And the first author probably would be the employee, but employee is nevertheless not considered as a first owner. So that this is the distinction you have to always bear in mind, that is authorship and ownership. Two are distinct. Now, in case of a government, say if I'm a government employee and then I develop a work, the first owner naturally would be the government and not the employee. As we seen in the beginning, as I was mentioning, that there are, every law has got exception. Even the copyright law has exceptions. What is this exception? That is, there are situations where one is permitted to use the copyright work of others without taking any permission. It's as simple as that. Okay, now how can I use without taking permission of the copyright holder? That is, if it is going to be for the purpose of private use, including research. The reason why I'm taking up this exceptions to copyright, because in many educational institutions, it is a common practice where tutors or the lecturers, professors, or the teaching faculty, they use the works, copyrighted works of others during the course for the purpose of, say, education or research. And in many institutions, we find where the teachers normally make course packs, that is, they do extractions of various authors, and then relevant passages are extracted from those original books, and then they compile them, and then they do the spiral binding, and then they circulate among the students. This is a very common practice. So whether such an act amounts or such an act falls under the one of the exemptions of the copyright, or is it a copyright infringement? That's a very important thing for us to understand. And the second exception is that there is a general exception which is provided where one can reproduce short passages from any original works. The first exception was with regard to private use, including research. Second exception is not for private use, but nevertheless, you are allowed to extract short passages. Now, what is this? How do you define short passages? Is it one paragraph, two paragraphs? What is it? So this particular definition is left to be defined for the judiciary and the lawyers. How do you define short passage? Okay, now when you continue with this fair use of this copyright work, we have a provision of law in Indian copyright which says, if the reproduction of a literary or dramatic, musical, or artistic work by a teacher, this is very important, by a teacher or a pupil in the course of instruction. So therefore, this exception applies only if it is done by a teacher or a pupil in the course of instruction. So what is important here is in the course of instruction. How do you define this? Is it a private instruction or instruction for money, or is it a free instruction? So on and so forth. So then there is or here. That means as a part of questions to be answered in an examination or in answers to such a questions. So that means if there is a reproduction of a questionnaire from a different source, say you are conducting an exam and you have reproduced a questionnaire from a book of a different author, which is already published, and then you take a part of questions from there, and then you ask students to answer those questions in the course of instruction, rather. So if you read this particular exceptions carefully, it appears that this exception is quite restrictive in nature, and then which allows a teacher or a pupil to reproduce a literary or dramatic work for the purpose of instruction and of course for the purpose of examination. Okay, after having looked at this definition of this law, then let's look at a practical case which came up in Delhi in the year 2012, and which was a very popular case. And this particular case is also a landmark case because it helped in interpreting the fair dealing or fair use, which is defined in the Indian copyright law. That is, what amounts to in the course of instruction, what is this private research, so on and so forth. Now, let's briefly look at this case. We have very little time now. And this was the case happened in Delhi School of Economics. And in that particular college, there was a photocopying center inside the college. And then Department of Economics entered into an agreement with the photocopying center saying that we will give you a book or books, and then you have to extract some copies, extracts from that book, pages from that book, and you have to copy, and then you have to charge about 40 paise per page, and this should be given to the students. So they had an agreement with that photocopying center. Then Oxford Press, which was one of the original publishers for the book that was being copied, that was being photocopied rather, they sued this photocopying center. For what? For copyright infringement. They say it is not a fair use because you are making money out of my book. Then, when it came before the court, these were the two prominent issues to be settled. First was, is photocopying amounts to reproduction? That was the first question. Second question was whether this reproduction happened in the course of instructions. That is, inside, whether the pupil, whether reproduced by a student inside the classroom or outside the classroom, or is it to facilitate imparting of knowledge by the teacher? So these were the issues that were raised to be addressed by the court in this case. Why, during the course of this litigation, there were also cases cited from other countries. Like, say, for example, in US, there was a case where a $2 million fine was imposed for reprinting portions of books, right? And in USA, in the Cambridge University Press case versus Becker, there they said, in the United States, they proposed a new method of identifying a threshold of the extent of copying from other source. They said you can copy up to 10% of the original work. How they arrived at 10%, nobody knows. Okay, now there was a similar case in Canada at the time. They said course packs fall within the purview of private study or research. So they had no problem. They said it's a fair use as far as as far as the reproduction is concerned. Now, in India, when this case came up, there was a lot of opposition, and many students and intellectuals, they came together to fight against the case against the Oxford Press. So in the course of proceedings, after they having come to know a case in US where they placed a threshold of 10%, here it was submitted that, see, they made an excerpt of, say, here you can see this is a course pack 1, course pack 2, total pages, number of pages copied. So they made an average calculation of how many pages they have taken from the original source, and they arrived at a calculation saying that that was 8.81%, which was less than the threshold of case law, which says 10%. Now, after having heard this matter, finally, it happened over a long period of time. And initially, the court granted injunction against the photocopying center. And when the photocopying center appealed against the decision, and what happened in this case was the court said, Copyright Act, that is, they interpreted the term fair use in the course of education rather broadly. They said, Copyright Act permits photocopying of copyrighted works for a preparation of course packs irrespective of the quantity. That's very important. Now we no longer stick to the 10% or 8%, so on and so forth. But the condition is that as long as it is for the purpose of educational instruction. Okay. So now, please don't go ahead and then do things saying that Mr. Suresh has said this so that you can use the copyrighted materials wherein you say that it is only for the education instructions. Please don't do that, because this is only a case law which is decided based on a particular facts. If the facts of the case are identical, then this particular case law would apply, otherwise not. So you have to exercise caution, even in the light of this case, to use copyright material for educational purposes. Okay. Now let's get into monkey business. So as you see a picture, this fun-loving monkey, very happy to see. And there is a big story behind this. Big in the sense. So this is a case where humans made monkey, tried to make rather, they tried to make a monkey as a copyright owner or a copyright author. It's a funny case. Well, in this case, in the year 2011, David Slater was a wildlife photographer. So he was visiting wildlife in Indonesia. So he wanted to take pictures of monkeys. So when he was trying to take pictures, those monkeys were very shy and they were not allowing him to capture them. So what he did, he created a tripod and he placed camera on top of it, and then he was watching what monkeys would do. So the monkeys were very excited seeing this camera placed on tripod, and then they were fiddling with this camera. So one such monkey, the black macaque monkey, was fiddling with this camera, and then it clicked that particular camera. So when they clicked that camera, there was a flash on the lens, and then that particular flash, or the what do you say, that that sound created a sort of surprise for a monkey, and then this was the expression of that monkey when it clicked that particular camera, clicked that shot. And then after this was done, and then the David Slater was very happy to see this picture taken by that monkey, black macaque monkey. And then when he came back, he published this on a Wikipedia. And then this particular photograph went viral. Many people liked it. And then the moment it went viral, problems also started coming up for David Slater. Then he appealed to Wikipedia saying that, look, this is my photograph, and then you should not publish it. Please withdraw it from your website or from the source. Then in this simultaneously in the year 2015, there was a case filed in the District Court of California in the name of Naruto. That is, in California, there is an organization for preventing this PETA. It's called Animal Welfare Organization. They went to the court of law and they filed a case. Since the case has to be filed with the name of a person or entity, so they're given this name, Naruto, to this monkey, and then they filed a case. So when this case was filed, when this came up for hearing, one argument was that, see, this photo was captured using the effort of a monkey, and there was no effort from the photographer. So therefore, this particular copyright legally belongs to monkey, but not to the photographer, right? And then a judge said, enough of this monkey business. They said monkeys cannot form a part of a system of law in US. Therefore, he dismissed the case. And then they went up to the federal circuit, which is equivalent to our high court here. There, this case became a butt of jokes because people started joking about many aspects of this case. How come monkey was brought to this court of law? Then ultimately, the case was dismissed, saying that copyright is only for humans, but not to anybody else like monkeys. Okay, case is sorted out. Now, then what happened to David Slater? So probably David Slater and the organization which had filed the case, they entered into sort of an arrangement wherein they say, okay, forget about this fight between monkeys and humans. So let us share the booty. So that's what it is. Eric, right now, after this copyright law, so we have few more minutes. Let me cover up with designs. So designs protects aesthetic features of a particular product. That is, what is this aesthetic features? Like if you have a shape, configuration, patterns, so on and so forth, you can get a protection under Indian Designs Act. What is the minimum requirement? Minimum requirement is that the design should be new or original. It is very essential to understand the difference between what is a new design or what is an original design. And before you obtain this design registration, you should ensure that this design was not present in public domain. That means it was not published. And also, your design should be significantly distinguishable from known designs. Okay. Now let's look at this picture here. This is nothing but a pen having a shape of Eiffel Tower, which is in Paris. Eiffel Tower is not a new design. However, here the pen with Eiffel Tower is an original design. Therefore, such designs can be registered as not as a new design, but as original design. Now, if you look at some of the exemplary registrations, Statute of Liberty in US, which is registered as a design, and the proceeds that were obtained using this design registration, they raised money to build the full statue in New York Harbor. So this particular design patent, which was filed, and based on the intellectual property right that they created, they were able to collect money, and ultimately they were able to build the Statue of Liberty in United States. And you can also see you can have designs for boxes, machines. It is also a requirement of design law that the design protection is for non-functional design. That is the way it looks, but not the way it functions. So you would be surprised to see where Indian design you have here, where engine is registered as a design. How is it possible? It's possible because in case a product has a combination of functional and non-functional features, what you are protecting is non-functional feature but not functional. And in particular, this non-functional designs or the feature should not be dictated by the functional aspects. So for example, I have a lock, I have a key. So lock has a particular lever configuration, and I have a key which fits into the lock, also has a particular corresponding design. So if you are trying to claim a design for the key, it would be difficult for you to say that it is a combination of both functional and non-functional, because only function that key has is to open the lock. So such a design may not be considered as a non-functional design. And you can also see a bed sheet with this chessboard design. So all these are possible under design. Let me quickly take you through an example of Coca-Cola bottle. In 1915, Coca-Cola's design shape was registered as a design. As you can see here, this is nothing but like a shape of a hobble skirt known as Christmas bottles in the year 1915. Shape of bottle. Then again, a second design patent was obtained for having these what you call say web-like features on the bottle, contour of the bottle. And this was registered as a second. In addition to the shape, you can see the contours, like if I can say the web-like features on the surface of the bottle. Then the bottle became that shape became so popular that they went and registered this particular shape as a trademark. Because, as you know, design registration is for a limited period, that is 10 years, or you can have an additional period of 5 years, total about 15 years. Whereas the protection for a trademark is indefinite. As long as trademark is used, you can exercise the rights. So therefore, what Coca-Cola did, once they realized the value of the design, they went and obtained the shape of the bottle as a trademark in addition to the design registration, because design registration is for a limited period. Now, if you look at the combination of intellectual property rights that Coca-Cola has for this is, that is design, trademarks, Coca-Cola and Coke, shape of the bottle, copyright they have in the form of advertising material and promotion material, and of course trade secret, which is the formula which we have seen last time. So just to conclude, copyright is for protecting expression of an idea. Moral rights survive even after the transfer of copyright. Designs are meant to protect aesthetic features which are non-functional in nature. And copyright and design laws are mutually exclusive laws, even though there is an overlap as far as the coverage of artistic work is concerned. Thank you very much.
Thank you, sir, for giving your valuable insights on copyrights and designs. So, dear participants, now it's your turn. You can ask any doubts, any questions on copyrights and designs, and please post your queries in the chat box. We'll address the same, or you can unmute yourself and can ask your questions. Sir, we'll wait for a minute.
Oh, yes, not a problem.
So let me ask you a doubt. Is there any relationship between plagiarism and copyright? Sir, can you hear me? Hello?
Yes. See, plagiarism that you mentioned about is nothing but copying a
Yeah.
source into a target.
Yeah.
So therefore, it does amount to copyright infringement
Oh,
as long as exception does not apply.
okay. So when we write manuscripts for journal publications, the publisher usually requires CTA, I mean, copyright transfer agreement. So actually, who owns this copyright to journals? Whether it
See,
belongs to the publisher or the author?
uh, that's a good question. See, if a journal is published
Yeah.
and you are using excerpts from that particular journal, the
Mm-hmm.
first question you have to decide is, whenever a journal is published, you have to look for a copyright notification, or what we say disclaimer, where they say, sometimes they say owners, all rights in the copyright or with the owners, or author claims exclusive copyright of this particular publication. If that being the case, the writers would become authors. And
Mm-hmm.
if that author has entered into an agreement with a publisher, by virtue of which publisher might have become owner. So you have to see the distinction. Author is the person who wrote that particular piece of work,
Mm-hmm.
and owner is the person who purchased those rights for publication. And now the question here is, from whom you should take permission.
Yeah.
So you should write to the publishers saying that, look, this is the purpose for which I am using this particular publication.
Mm-hmm.
And then you should obtain permission from the publishers. And if publishers says, okay, I don't have much rights in this because I'm only authorized to publish this, please approach a author because they are the authors. Then probably you have to seek permission from the authors as well to be on safe side.
Okay. Yeah, fine. So, sir, one more doubt from my side.
Sure.
So, do copyright laws protect clothing designs?
Yes,
Uh,
patents. Yes, as I was mentioning, these
so,
patents.
so does it just protect its design or its drawings only, or the whole production clothing?
That's a good question. In fact, uh, here we have to see what is the copyright and what is it that it protects. Copyrights protects, it's the work of an author. The work in the sense, the drawings. You create a pattern on a
Yeah.
piece of medium, that
Yeah.
is what is protected. If that is transferred onto your blanket and the blanket is sold, then you don't have the person who has purchased that is the owner of that particular goods with that copyright design.
Mm-hmm.
So you cannot stop that particular owner to do whatever he wants with that blanket. What you could probably stop is that he could not use this particular pattern of yours for creating a blanket having similar or identical design.
Okay. Okay, sir.
So
Okay.
to answer to your question, that is copyright exists in the drawing.
Mm-hmm. Okay. Okay. Thank you, sir. Thank
You're
you.
welcome.
So, any more doubts from the participant side? I think no questions has been raised in the chat box. So now I invite Assistant Professor Jarangio Jacob from Department of AI to deliver the word of thanks.
Thank you, CG Miss. So it's an amazing moment that we are passing through right now because we have completed a series of webinars that is organized under the tag name Intellectual Property Rights, and the final session on the designs and copyright and designs have just gotten over. And our resource person, Advocate J. Suresh sir, have been a wonderful person, a wonderful resourceful person actually. He shared all his knowledge on this topic, helped us understand what is the intellectual property rights, what can be protected under this rights, and what all things come under this property rights and copyrights and patents. Everything he have addressed. Thank you so much, sir, for giving us such an informative sessions and sharing your knowledge. Thank you so much, sir.
You're
We
welcome
expect you.
always.
Yes, sir. We expect you to have more sessions with us, sir. To be
Sure.
honest. Yeah.
Sure, it would be my pleasure.
Yeah. All right. Thank you so much, sir.
You're welcome.
We have more gratitude towards our college management for supporting us and providing us all the support that we need for organizing this webinar. We are also thankful to our principal, Dr. Matthew K. He always motivated us in organizing this sessions, as this area was kind of unknown for most of the people. So I believe his motivation helped us in organizing this. And we thank our academic coordinator, Professor Ranjit Suwogi sir, for giving us the support and guidance in organizing this. Also, a special thanks and mention is needed for our coordinators who worked hard behind this program. Our coordinators, Dr. Smita C. Thomas and Assistant Professor Ajay sir, for all the works that is done behind this uh, webinar series. So we are thankful for all the participants. A great thanks to all the persons who have watched the series or attended the series and influentially, like say, gathered the knowledge in this webinar series. Thank you so much, all the participants. Also, especially thankful to all the persons who have joined today's webinar. Thank you so much, everyone. We will be organizing more webinars like this. We hope we can use Suresh sir in our future sessions as well. We expect you to participate in all our webinars that are being organized in the future. Thank you so much, every participants. The feedback will be given in the chat box. Everyone have to fill it for your attendance marking and for getting your entry for the certificate. Thank you so much, everyone. Once again, have a great day. Thank you so much, everyone.
Thank you, Jarin sir. Dr. Mohindran sir, do you have something to share with us?
I don't know anything to share. In fact, I was also enjoying all the three. Sessions of Suresh. Suresh is a very good friend of mine. Not now, but from back. We were when we were in law school. We used to just share a lot of things, and then even last week also we were together in the university. Program. Okay, and then one session was his, and the next was mine was fast, and the next was his, and then it was wonderful. So he's always a great resourceful person, and then he should be made use by all the universities, especially the technological universities, need these type of people. That's what we are planning to introduce some special course for, tech keys, especially for them. If their invention, how are they going to be motivated to just, invent and design, register them? These are all the areas it is required. And there is another course is called BE LLB, okay, just like BSc LLB, BA LLB, BCom LLB, BE LLB, and MBBS LLB is also there. That type of courses, in future, if we have, what happens, integrated courses on these issues. When you want to be a patent lawyer, you should be a science or engineering background. Otherwise, you can't even argue in the court of law. There is a special examination. And then Suresh is a BSc. That is the reason he could be a patent lawyer, and then he got so much of expertise in this field. So this is a very, very important technical area. And then the first day, what he was saying, totally 50,000 patent applications are there. In that 60% is from, multinationals. So we are not lagging behind. Somewhere we are not being motivated properly. Our own youngsters ought to be motivated a little more. And I'm sure we are going to just, this is the area, any company's balance sheet is going to be really increased because of this particular intangible worth. That has to be increased in our country. And I'm sure most of the enthusiastic students participated. I'm happy. Very good thing. Mount Zion Engineering College has organized this particular thing. Thank you very much, my dear Suresh, and then you have done a wonderful job for us. Thank you very much. All the
Thank
best.
you. Thank you. Thank you very much, sir. It's my pleasure.
Thank you, sir. Thank you all for your cooperation. Have a nice time. Take care. Be safe.
You too. Bye bye now.
Bye.